A middle school teacher refers her 14-year-old student, Marcus, to a mental health therapist with whom the school contracts. Marcus has been acting out in class lately, and she wants to determine if he needs any supportive services. The contracted therapist conducts an assessment and refers Marcus to a community outpatient mental health provider for treatment. The teacher asks the therapist about the results of the assessment and what services the therapist recommends. Fast forward to the following year, Marcus is now in high school where he is exhibiting aggressive behaviors and has come to school intoxicated on a few occasions. The high school principal contacts the middle school counselor, who tells him that the contracted mental health therapist conducted an assessment and made referrals. The principal then calls the therapist to ask for the results of the assessment and what treatment plan was implemented. In the meantime, the principal refers Marcus to the school's student assistance program for substance abuse counseling and to the same community mental health agency to which the middle school referred Marcus last year. The principal tells the SAP coordinator to keep him posted on Marcus's progress. The SAP coordinator contacts the community mental health agency to find out if Marcus did any therapy there last year.
Okay, true story. This was an actual scenario sent in by someone. So let's start. Obviously, there are multiple people involved here and multiple laws are in play. So who has information here that others want to get? Anyone who wants to volunteer? Okay, well, I'll just jump in. So we've got a couple of actors here who have information. We have the mental health therapist who's working at the school. We have a community mental health agency, and we have a substance abuse program at the school. They all have pertinent information about Marcus at different points in the recent past. And among these actors, the middle school teacher is asking the school mental health therapist for information. Specifically, they want to know the results of Marcus's assessment and what services the therapist recommended. The high school principal in this case is making multiple requests. First, he is when Marcus gets to his school and is acting out and having problems, he reaches back out to the middle school and specifically asks the middle school therapist for, again, also the results of the assessment and what kind of treatment plan was implemented. He also knows that Marcus is in his own school getting substance abuse treatment, so he reaches out to the person who's running that program to say, just keep me informed of the kid's progress. And finally, that substance abuse program counselor is reaching out to the community mental health agency where they know that the middle school sent Marcus the year before to get therapy, to find out if he actually did do any therapy at the agency. So a lot of people in play, a lot of requests for information, a lot of laws in play. What does the requester want to do with the information? The middle school teacher here, it's very clear. He says he wants to know what support should be provided to Marcus. It's not clear what the high school principal wants to do with the information. We're going to presume that he wants to do the information for the same reason, to figure out what supports to put in place for Marcus. So the question becomes then, what information is governed by what law? So let's start with the school-based mental health counselor. Again, we go back to our, oops, my thing fell down, excuse me. We go back to our little chart here of HIPAA versus FERPA. What do we think governs, which law governs the information that the school-based mental health counselor has about Marcus in this scenario? I hear both. I'm going with FERPA on this because they are employed by the school. It says that they're contracted with the school. They're contracting with the school. Arguably, this is one of those situations where you'd have to double check with your legal counsel as to what they're saying, what law this person is governed by, because arguably I can make arguments on both sides. That's what lawyers are famous for. But I'm going to go with the fact that the mental health therapist is contracting to bring in the services. Let's say for this scenario that it's FERPA. If it was FERPA, then for the anyone in the school to get the information, we would have to, the easiest thing obviously would be to get parental consent from Marcus's parent for the counselor to share information with the teacher, with the high school principal. In lieu of getting that consent, again, there are a couple of things that can be invoked here. The most important one is this, again, legitimate school interest exception. If, in fact, the school has a policy of putting out in its notification to parents that information that's given to the mental health therapist will be provided to other designated school personnel because they need to know that information to carry out their responsibilities, FERPA would in fact allow that disclosure to happen. Again, the key here is notice to the parents that this is how we define a school official, this is how we define a legitimate educational interest. The other thing at play here is the information that the Student Assistance Program, the Substance Abuse Counseling Program has regarding Marcus's treatment, progress in treatment. That one is clearly going to be governed by, absolutely, right? 42 CFR governs the provision of substance abuse, governs records regarding the provision of substance abuse treatment, even in schools. There is HHS guidance on this, that in fact those laws do apply. So in that case, one of the important things to ask as to whether or not the principal can get access to information about Marcus is who had to consent for Marcus's substance abuse treatment. Here it says that Marcus is 14 years old. Here in Colorado, I understand as a 14-year-old, you wouldn't be able to consent to that treatment, that Marcus would need parental consent to get substance abuse treatment, whether or not he was doing it in school or an outside provider. So what the federal DNA regs would say is that it would be Marcus's parents who would have to sign off on some type of release for the substance abuse counselor in the school to give information to the principal. So finally, the third actor that we have, did I see a hand? Please. Sure, can you just wait for the mic?
If the mental health counselor is contracted by the school district and paid by the school district, then that comes under FERPA.
That's generally what the guidance that has come out of the feds. And
so if the mental health counselor is providing services under the auspices of the school-based health center and that has a lead medical agency, then the district is not paying for that service. And I know that as one of those agencies, our people would say that that information falls under HIPAA. Is that, am I
that's
defining
my
that?
understanding. Yeah,
Okay.
I mean, yes. I mean,
So contracted is just a little ambiguous. If they're contracted and paid by the district, that's FERPA. If they have a relationship with the district, but they're paid by a mental health agency, then it's HIPAA. Okay, thanks.
Right. I mean, that's what the guidance has said, basically, and that's why it's important. In here, I said FERPA because I said basically, in the answer sheet you're going to see, if the counselor is a school employee, her ability to share is governed by FERPA. If she's employed by a healthcare provider outside of the school, it's likely that he or she has to follow the HIPAA confidentiality rules. What I basically say is, the answer is not clear cut. You have to ask, who is the employer and who's paying for it, to figure out which, the student or the parents always own the record, but what rules govern you have to ask that question. In this scenario, it was vague enough that it could go either way. Did someone else have a question? Okay, so we talked about the release of, The records that the mental health counselor who was working at the school had. We talked about the records by the SAP program coordinator who provides substance abuse treatment. The last piece of information was they wanted to get information. The principal asked the SAP coordinator to call the local mental health agency to ask them what was happening with Marcus. Was Marcus actually going to get treatment there? The law that governs the mental health agency's ability to release information is? Fill in the blank. HIPAA, clearly HIPAA. It's outside. There's no school involvement here, so we don't have that tricky question to figure out. HIPAA would rule. Again, the question of the only way that then that agency can release information back to the school about Marcus's treatment would be if they get a signed release. If Marcus was in Colorado as a 14-year-old, his parent would have to sign for him to get mental health treatment. So as per HIPAA, that would mean that Marcus's parent would have to sign any kind of authorization for the community mental health agency to release the information back to school. I mean, unless it would fit under one of these other exceptions, but it really wouldn't in this case. I couldn't think of an exception under HIPAA that would apply to a non-court involved. This kid isn't involved in any kind of juvenile justice or child welfare proceeding at this point. So likely no one's going to generate some type of court order to get those records.